We have breaking news. We're going to get right to it. The NRA versus Vullo case in the United States Supreme Court was argued today. A big back and forth involving the First Amendment and whether or not the state of New York, under Andrew Cuomo and different bureaucrats associated with that administration, did by virtue of alleged threats to third-party finance companies such as insurance companies and banks and the like, all of which were regulated by the state of New York, whether or not those threats caused them to stop doing business with the NRA to the harm of the NRA. And this viewpoint discrimination allegedly by the state of New York, did this cost the NRA money and was this illegal under the First Amendment? Big argument today. And just as a reminder, the way this case broke down is you had the Parkland school shooting in February of 2018. Shortly thereafter, there was this massive outpour of really anti-gun, anti-Second Amendment, anti-NRA-like efforts all across the corporate boardrooms of America. And part of what went on there was the state of New York really went after the NRA in all sorts of ways. And one of the ways they did it was to try to claim that the NRA insurance-related programs were illegal and didn't comply with certain regulations. We won't bore you with the details here. The bottom line is that the NRA sued the state of New York and various bureaucrats working for the state of New York for violation of their First Amendment rights of free speech. Specifically, they said the state of New York engaged in behavior that was illegal because they did things to the NRA and to NRA business partners, specifically because they did not like the NRA's pro-gun, pro-Second Amendment message, and this was unconstitutional under the First Amendment. Nevertheless, what I'd like to do now is just play you some of the highlights of this argument, starting off with the NRA's opening statement, which I will play for right here and right now.
Government officials are free to urge people not to support political groups they oppose. What they cannot do is use their regulatory might to add "or else" to that request. Respondent Vullo did just that. Not content to rely on the force of her ideas, she abused the coercive power of her office. In February 2018, she told Lloyd's, the insurance underwriter, that she'd go easy on its unrelated insurance violations if it aided her campaign to weaken the NRA by halting all business with the group. Lloyd's agreed. 6 weeks later, she issued guidance letters and a press release directing the thousands of banks and insurance companies that she directly oversees to cut off their ties with the NRA, not because of any alleged illegality, but because they promote guns. In the accompanying press release, Vullo's boss and co-defendant, Governor Andrew Cuomo, said he directed Vullo to issue the guidance because doing business with the NRA, quote, sends the wrong message, unquote. Shortly thereafter, Vullo extracted legally binding consent orders from the NRA's 3 principal insurance providers, barring them from ever providing affinity insurance to the group ever again, no matter how lawfully they do so. These actions worked as multiple financial institutions refused to do business with the NRA, citing Vullo's threats. This was not about enforcing insurance law or mere government speech. It was a campaign by the state's highest political officials to use their power to coerce a boycott of a political advocacy organization because they disagreed with its advocacy. Governor Cuomo essentially conceded as much in 2 tweets responding to this lawsuit, in which he said, and I quote, "The regulations New York put in place are working. We're forcing the NRA into financial jeopardy. We won't stop until we shut them down. It's time to put the gun lobby out of business. Hashtag bankrupt the NRA." At the motion to dismiss stage, the only question is whether these allegations, taken as a whole, plausibly plead a First Amendment claim. Because Vullo chose coercion over persuasion, they do.
Now, the next thing is that Justice Sotomayor really tried to get down and try to understand what exactly was it that the NRA wanted in terms of what would they like to see the opinion written by the U.S. Supreme Court to say. This is what Justice Sotomayor had to say about the issue in this case.
So how would you write it differently than the district court did, number one? And number two, how would you write it differently than the SG would?
I would write it that Bantam Books holds that when government officials encourage third parties to penalize a speaker because of its views, they cannot use coercion to further that end. Here, respondent used coercion.
And what do you define as coercion?
The threat, implicit or explicit, and my friend agrees they can be implicit or explicit, of coercive government action, that's coercion. And here she explicitly threatened that to Lloyd. She said, I'll go easy on you if you cut your ties with the NRA. That's the same as I'll go hard on you if you don't cut your ties with the NRA. She invoked her authority to punish organizations and financial institutions with respect to failing to manage reputational risk, and made it clear that what she meant by manage reputational risk was cut your ties with the NRA. And then she very shortly thereafter announced these consent orders with three of the NRA's principal insurance providers, in which she not only punishes them for insurance infractions, but imposes an extraordinary ban, a lifetime ban, in perpetuity. These organizations can never provide affinity insurance to the NRA, even if every T is crossed and every I is dotted under New York law. And with respect to Chubb, one of the three, she got them to agree not to provide insurance to the NRA anywhere in the country, not just in New York. She has no jurisdiction out there. So I think when you look at those three, and I think you under Bantam Books, you have to look at the government's action as a whole. You see that she encouraged third parties, insurance companies and banks.
Of course, in response to that, the state of New York had a big comeback. They had a big argument against this. They claimed there was no violation of the First Amendment in this context, that the government of the state of New York basically has First Amendment rights, and they're allowed to encourage people to do good or bad things, but whatever they are, they have a First Amendment right too, and as long as they're not threatening to discriminate against someone or threatening regulatory action, it's consistent with the First Amendment. Here is essentially the essence of New York State's arguments today before the Supreme Court.
Thank you, Mr. Chief Justice, and may it please the Court. The key fact in this case is the conceded illegal conduct. As Justice Sotomayor said, the three insurers in the NRA broke the law. They were selling intentional criminal act insurance, and all of the products they offered were unlawful because the NRA refused to get a license. That's why Bantam Books is miles away from this case, and it's why the court below found qualified immunity protects Vullo. In this posture, Iqbal demands courts ask, as between the invidious coercion asserted or the obvious explanation she was enforcing the law, is coercion plausible? When illegal action is present, the plausibility burden is higher. To use Mr. Cole's phrase, the government is more likely responding to conduct than, not speech, and four separate doctrines explain why. First, Iqbal held plausibility rules are, quote, especially important in suits where government defendants assert qualified immunity because they must be neither deterred nor distracted from vigorous performance by disruptive discovery. Second, the presumption of regularity is at its height. Third, absolute immunity protects enforcement actions. And fourth, causation is more difficult. That is particularly so after Parkland, which led many businesses that Ms. Vullo has no control over, such as United Airlines and Avis Cars, to sever ties with the NRA. Were this court to accept this thin complaint in the teeth of the conceded illegal conduct, it would empower strike suits to enjoin valid enforcement and open sensitive discovery. That's why the court's traditional test here is right. A government official crosses the line from coercion to persuasion when, one, when they are threatening as opposed to encouraging, and two, there is no objectively reasonable basis for their action. The NRA can't meet that test, and that's why they are seeking to weaponize the First Amendment and exempt themselves from the rules that govern you and me, simply because they're a controversial speaker.
And last but not least, Justice Alito, always good for some good questions. Here's a very interesting question he asked about pistols, believe it or not. A really interesting question trying to get to the heart of the matter about threats and legitimate government behavior and illegitimate government behavior under the First Amendment's right to free speech. And again, the government is not supposed to engage in viewpoint discrimination by basically applying the law favorably to people who have views, political views that they support, and applying the law unfavorably to people whose political views they don't support. And this is a classic example of a First Amendment violation. And here's Justice Alito trying to get to the heart of the matter by asking questions of the lawyer for the state of New York right here, right now.
I'm really, this is kind of, suppose the allegation was We had a meeting with Ms. Vullo, and she pulled out a pistol, and she held it to our heads, and she said, "I'm going to blow your brains out unless you stop writing insurance for the NRA." That would not be enough to even allege a Bantam Books violation, because she might have taken that same regulatory action. She might have taken regulatory action for a perfectly legitimate reason.
Your Honor, the government's conduct would be objectively unreasonable and it would flunk our test. So we think this is not a hard test. We're not seeking to change the law. We're just pointing out that when you're in a situation like this of conceded illegality, that there is an obvious alternative explanation for what Ms. Vullo was doing here, which was enforcing the law. And this is the worst case in order for you to say this should go past 12b-6, because if you allow this case with its conceded illegality to go past 12b-6, then I think any plaintiff will be able to do this.
So that's where we have it. This is a major First Amendment case. Lawyers for the ACLU argued on behalf of the NRA. I think that's a good thing for the NRA. The Solicitor General of the United States for the Biden administration, by the way, argued also in favor of the NRA, but they wanted a very narrow ruling. We can talk about that in a future video, but for now, that is the highlights of today's argument. We will cover this in greater detail in a future video. I'll break it down in more and more geeky, but for now, I just wanted to give you the highlights and to let you know this is where it's going to go. I suspect the NRA is going to win this case. They're probably going to win this case 9-0. So what we're going to really care about is the scope of the decision. What does the court say about what constitutes a First Amendment violation versus what does not? That's really where the rubber is going to hit the road as to whether or not this decision by the Supreme Court, which I think will be in favor of the NRA, is going to have a lot of teeth for the conservative movement and the Second Amendment movement all across the board going forward. We will find out probably the last week of June. So there you have it. Hope you learned something here today. Make sure you subscribe and resubscribe here. Make sure you follow me on X at 4Boxes Diner, and we will see you again soon at the 4Boxes Diner.
Orders up. Table 2A.